It's 6 o'clock, and I think we should officially start. My name is Miodrag Jovanovic. I'm a professor of the Faculty of Law, University of Belgrade. My colleague and friend Bojan Spajic is associate professor of this faculty, and two of us will moderate this symposium on the question, the most important problem of the current legal philosophy. The symposium is organized by the Belgrade Legal Theory Group, which is the unit of the IVR section, and the Belgrade Law Review, the journal of the Faculty of Law, the University of Belgrade. Our idea was to gather some of the most prominent representatives of the generation that has largely set the tone of jurisprudential debates in the last decades. Although I'm pretty much sure that we are all fed up with these online meetings and gatherings, they are at least more convenient option if you want to gather people from all around the world. And particularly having in mind how generous are universities in funding events in legal philosophy as well. So we'll take the advantage of this device, but in real hope that we will have the opportunity to meet very soon in person. Eventually, all the planned participants are here, and I wish to thank them once again for accepting the proposal to take part in this event. Let me just brief you, tell how the format of the symposium is envisaged. Each of the 5 panelists will have 15 to 20 minutes for their presentation. Then we will go into a round of their comments, and this will also be the round in which we will maybe pick a couple of questions from the audience, but the question will not be posed directly. That is, the questions will be put only in the chat section, and we as moderators will pick up a couple of questions which will be simply kind of a continuation of the debate. And after this, so to say, the middle part of the format, in the last round, each of the panelists will have the kind of the last words of the or the last comments, and altogether we plan this event to last around 2.5 hours. So it will be a bit tough, but hopefully by the end of the day, hopefully we will all leave this virtual space with a lot of satisfaction. And in order to keep in time with this envisaged setting, I give the floor first to Brian. We will go in alphabetical order. So first Brian, then Frederick, then Pierluigi, then Tomasz, and eventually Torben. So Brian, the floor is yours.
Okay, thank you, and thank you, Miodrag and Bojan, for organizing. I would love it if other people would turn their screens on. It's much easier to talk to little faces than it is to talk to blanks. Thanks. Okay, so I know I have about 20 minutes, so I'm going to talk a bit quickly so I can get it all in. You know, the subject, right, the biggest problem or the most important problem of contemporary legal philosophy is ambiguous in a funny way between particular puzzles or questions that are very important versus problems in legal philosophy or the problematic situation in contemporary legal philosophy. And I'm going to talk about both, and I'm going to start with what I take to be the problematic situation in legal philosophy, and especially in Anglophone legal philosophy, and especially in the United States. So those of you who are working in legal philosophy in jurisdictions not afflicted with these problems, you can all be grateful, as it were. My worry is that legal philosophy in the United States is backsliding very seriously. We are losing sight of a lot of things that I thought we had learned from HLA Hart and from Kelsen, though often Kelsen through Hart. I think we learned a lot from aspects of Dworkin's engagement with Hart, from Raz's additions and disagreements with Hart, even the major natural law challenges to Hart. I'm thinking of Finnis and Mark Murphy. Even those challenges, in effect, accepted a lot of Hart's way of framing the issues and the questions of legal philosophy, and really took issue with Hart in a way at the margins, namely questions about the methodology of legal philosophy and whether the question what the law is can really be separated from the question what it ought to be. The same thing is true of my own earlier sort of naturalistic challenges to aspects of Hart's legal philosophy. The problem is it's well captured by something that my friend Leslie Green often says that is very apt. He says, too many legal philosophers want to say something new rather than something true. And of course, the incentive structure of academia encourages finding something new to say, regardless of whether it is true. And I think we are suffering from that in the United States in particular, with a proliferation of new theories of law, most of which are new, but none of which, as far as I can see, are true. I want to comment in particular on Scott Shapiro's so-called planning theory of law, because I think it is a particularly problematic case precisely because he did present himself as trying to continue in the tradition of legal positivism associated with Hart, right? Some of what I have to say about this is discussed in more detail in a paper that you can get online at SSRN called Critical Remarks on Shapiro's Legality and the Turn in Recent Jurisprudence. I'm not going to go over everything I said here. I just want to highlight a couple of things that seem to me a real move backwards in the field. So let's start with the most obvious thing, which is that the whole idea that you can have a planning theory of law shows that Shapiro's already forgotten something that I thought we had all learned from HLA Hart, which is that law can result from the unintentional activities and practices of officials in a legal system, right? Some law does result from plans, but a great deal of it doesn't. And this was, in fact, one of Hart's important insights. That's already off the table. Scott has popularized the idea that Hart somehow committed a category mistake in equating rules with practices. The idea being that rules are abstract objects, practices are concrete activities. It's a category mistake to equate them. This is the single stupidest objection to HLA Hart I have ever, I think, heard from a serious person. Scott is a very serious person, right? Hart did not, in fact, equate rules and practices, right? Hart argued for an analysis of what it is for people to accept a rule, right? And he said the evidence that people accept the rule is to be found in the practices that they engage in. The unit of analysis was the acceptance of a rule. It's quite explicit in the concept of law. The unit of analysis was not a rule. Some people have responded to this. This is what Gardner and Macklem say, and this is another way at it. They say, look, what was equated was the content of the rule with the content of a practice. Contents of the same metaphysical category, no category mistake. You know? Another thing that Shapiro claims, which I think is pernicious and confusing, is he says that in order to know what the law is in a particular case, and I quote him now, it's not enough to know who has authority within the jurisdiction, which texts they have produced, approved, and how to interpret them. It's utterly mysterious how it could not be enough to know what the law is if you know who has authority within the jurisdiction, which text they produced, and how to interpret them. Right? And in fact, he doesn't show that that isn't sufficient. But part of what's going on here is I think he's got the Dworkinian bug, right, which has always been anathema to legal positivism, of thinking that judicial decision actually requires you to have a general or foundational view about the nature of law, right? What the law is one thing. What judges ought to do is a separate question. So these are some particular theses that Scott has advanced in his book that I think represent a real move backwards from things that we learned from. Though I think the real damage in that his book has done is not so much the particular false claims that he has made. I've mentioned a few of them, and I think a lot of people are aware of some of these problems. It's rather that he's popularized what I think is a very strange way of framing the problems of general jurisprudence, namely in terms of metaphysical grounding relations, which is, as it were, the current fad in analytic philosophy. Analytic philosophy, as many of you may know, is a degenerating research program at this point, and the current fad is metaphysical grounding, right? But what's so puzzling about this is that it makes it sound like the real problem in philosophy of law is to find law's place in what you might call a metaphysical layer cake, where one layer of the cake, right, is supposed to be the law facts, and then there's these other layers: social facts, moral facts, psychological facts. I don't know, all kinds of facts maybe are somewhere in this cake. And the task is to figure out how the different layers are all connected to each other. Now, all of this grows out of the fact that Raz sometimes would say that law is a matter of social facts, right? But, and that's taken to mean, okay, then the positivist says law is nothing more than is constituted by social facts, and the natural law theorist says, no, law is constituted by social facts and moral facts, and on, okay? But Raz himself, when he says law is a matter of social facts, explicitly calls it a crude statement, right? It really wasn't meant to be an invitation to general metaphysics. It was rather a shorthand for the whole complex of ideas that we, in fact, got from Hart, right? So these are ideas like law is fundamentally conventional, right? That is, what law is rests at bottom on a purely conventional practice of officials in a legal system of converging on certain criteria of legal validity and accepting them from an internal point of view, treating them as in some sense obligatory. That law is not necessarily coercive, that law consists of a union of primary and secondary rules, that the secondary rules have to be social rules, and so on, right? And I think all of this is lost when you frame the question of jurisprudence as questions about metaphysical grounding relations. I also, just as an aside, worry we're setting an impossible task, right? It's an impossible task because I would have thought we learned from Kripkenstein's attack on the idea that we could specify the facts in virtue of which some phrase has a determinate meaning, and from Nelson Goodman's new paradox of induction, right, which shows that we can't, in fact, specify the facts that will allow us to reliably project any particular predicate into the future. These kinds of famous examples in philosophy might have led one to worry that in setting out to say how facts make law, to use Mark Greenberg's phrase, and I think Greenberg was a very big influence on Shapiro's framing of this, that this isn't going to be a successful undertaking. Right? So this seems to me a problem in legal philosophy in the sense that it's derailed things in a very unproductive way. But it has appealed to people who've recently gotten PhDs in analytic departments who like to talk about metaphysical grounding. I would hope that legal philosophers will not all succumb to this confused way of thinking about the issues. And so with that, let me turn to what I think is the main problem in the other sense, but closely now related to what I've just said, which is I think what we need is something like at least an Anglophone jurisprudence, working in the continental traditions. They have a very different take on this, though I think we would all benefit from what I would call a back to Hart moment, right? In mid-19th century Germany, they had a back to Kant after they got through with Hegel, which was an ordeal. I think we need a little bit of a back to Hart. That is, I think there are some issues having to do with understanding what Hart's contribution was that are particularly important and that would be worthy of our attention. Okay, I'm going to mention just two. One is the question of theoretical disagreements, right? You know, the Hart-Dworkin debate is kind of a zombie. It never dies. But the current version of it that's come up, the problem of theoretical disagreements, I think does actually pose an interesting question for positivist theories of law. Now, Dworkin himself made the claim that because positivism couldn't explain the face value of theoretical disagreements about the criteria of legal validity, Dworkin said this shows that positivism fails as a theory of law. This was an obvious non sequitur. Theoretical disagreements are one kind of phenomenon that we associate with legal systems. They aren't the only one that a theory of law is supposed to explain. Right? As I've argued, positivists can give an explanation of theoretical disagreements, though it is one that explains them away. Right? The fact that you explain something away, you explain the face value of something away, is not, without more being said, an objection to the explanation, right? My view is that where we have genuine theoretical disagreements, and I think they're very uncommon, right? The participants are making a certain kind of very abstract error about the nature of law. If there really is no fact of the matter about what criteria the officials converge upon and accept from an internal point of view, then there simply is no fact of the matter about what the criterion of legal validity is. Those who say otherwise are simply making a mistake, a totally understandable mistake, since judges can be perfectly competent in what they're doing without having a worked out theory about the nature of law. But there's another possibility here, an alternative to my error theoretic interpretation of theoretical disagreements. And this has been less explored, right? Though Torben, in his paper in the Cambridge Companion to Legal Positivism, touches on this possibility. I have a PhD student here, Aaron Graham, who is working on a version of this. And don't worry, Torben, I made him look at your paper. And this is the possibility that it's a mistake to grant Dworkin that a rule of recognition has to include among the criteria of legal validity, right, claims about how the sources of law are to actually be interpreted, right? Because that's really what's motivating Dworkin's position. Maybe a rule of recognition only specifies the valid sources of law and nothing more. And so even in Riggs v. Palmer, the judges agree on the sources of law and their disagreement about interpretation. Right? In Elmer's case, as Dworkin calls it in Law's Empire, their disagreement about how to interpret the sources of law is just not a disagreement about the criteria of legal validity, but a disagreement about interpretation. They agree on what the valid sources of law are. They disagree about how to fix their meaning. Right? The difficulty that confronts this approach, and I raised this with Torben a while ago at the conference preceding the Cambridge Companion to Legal Positivism, and I've been pressing on Mr. Graham, my student here, is the rule of recognition is supposed to fulfill an epistemic function, right? That is, it's supposed to enable us to identify which norms are legally valid norms. And so it seems we have to know a little bit more than just what the sources of law are. We have to know, as it were, what norms the sources actually enact, which might seem to drag us into questions of how the sources are to be interpreted, right? Unless we can, as it were, distinguish between the sorts of interpretive disputes that form the bases for the theoretical disagreements Dworkin talks about, and the way in which the sources of law have meaning prior to that kind of interpretive exercise, right? So it's going to require some distinction between understanding the meaning of the sources versus engaging in the interpretation of the sources. So that seems to me an interesting and important question that represents an area of live and ongoing debate. The second issue where I think we could benefit from further investigation in our effort to get back to Hart concerns how he conceives of the internal point of view. Right? Is it enough to simply talk the talk and walk the walk to adopt the internal point of view? That is to say the right things and do the right things, right? And if so, does that mean someone can take the internal point of view while only doing the job for the money, as it were, which is actually something Shapiro suggests might be possible. Okay. Now, it seems to me that this debate, right, is uh, is taking advantage of the fact that Hart himself, right, is in the grips of something like Gilbert Ryle's view about what it is to be in a mental state, right? Gilbert Ryle wrote The Concept of Mind, which is why H.L.A. Hart misleadingly called his book The Concept of Law, because that's what Oxford philosophers did. But I think the Ryle influence goes a little deeper. Ryle said if you're in a mental state, right, that is just equivalent to certain manifesting certain behaviors or having a disposition to engage in certain kinds of behaviors. Right? And I think that Hart takes this over in the sense that he wants to characterize the internal point of view in purely behavioral terms, right? That is, people converge on certain criteria, and then they say certain things. They say you must use these criteria of legal validity. They criticize those who deviate from those criteria and so on. And of course, Hart goes out of his way to criticize the suggestion he associates with Alf Ross that adopting the internal point of view is a matter of having a certain feeling. Right? But the reason he's doing that, right, I think one of the reasons he's doing that is because he's operating with Ryle's assumption that it suffices for the ascription of an internal attitude to an agent to simply allude to the behavior that the agent manifests. Now, the thing is, very few of us, if any of us, are in the grips of Gilbert Ryle's behaviorism about the mental anymore, right? And I think this leads certain interpreters, when they see that Hart only says you have to talk the talk and walk the walk to have the internal point of view, to say, wait a minute, we know that people can say things and do things but not really mean it, right? And so we're appealing to the very un-Rylean distinction between what the agent, how things really look to the agent versus what the agent, the face the agent is presenting to the world. And the point is that distinction, I think, in Hart's mind, and I don't think it's available in Ryle. And so if that's right, if we forget the sort of behaviorist prejudice that I think undergirds Hart's treatment, I do think we have to rethink whether or not the internal point of view is a bit more demanding, such that, right, agents couldn't simply talk the talk and walk the walk, but not believe any of it. That is, not feel that there's that word feel, not feel that the rule of recognition is in some sense obligatory or something like obligatory, right? I say something like obligatory because obligation for Hart is also just analyzed in terms of the use of certain language and certain behavior, right? Severe social criticism, right, is one of the indicators. The use of the language about must and ought and so on. Okay, that's where I will stop. Thanks very much.
Thank you, Thank you so much, Brian. Two topics to think about and to discuss about. I won't be making any plugs. I see a lot of colleagues here, even some that wrote about your first topic. For example, Luca Burazin with Giovanni Battista Ratti. I can't see here, but Luca definitely published something about the character of rule of recognition in identifying valid sources of law, interpretation being an aside and quite separate from this question that Dworkin rose. Brian was in Belgrade, so we had the opportunity to host him live. He was our guest. Our second guest was supposed to come to Belgrade, but the pandemic made those plans, prolonged our plans for bringing him to Belgrade. So he obviously, like Brian, needs no introduction. Fred, the floor is yours.
Okay, thank you. Yes, I will. I am sorry I could not be there in person. I look forward to doing it at some point in the not too distant future, now that travel is again possible. So the task for us, the task that has been set for us, is to try to identify the most important question in legal philosophy. I think there is a temptation to equate the most important question with what it is that I work on. I want to largely resist that temptation. I want to describe what I think is the most important question, only one corner of which is something that I work on myself. I also should mention in this context, I am somewhat proud of the fact that I don't use the word theory and I don't have a theory of law. I may use other people's accounts, a better word than theory, but neither here nor anywhere else will I offer a theory of law. I have some sympathy with Oliver Wendell Holmes when he said, I care nothing for the systems, only the insights. So the best we can do perhaps is interstitial observations. So having said that, the question I want to address, or the question that is the answer to the question that was put to us, is, put simply, does law matter? I think the question, does law matter, can be subdivided into 4 parts, and I'll talk about those 4 parts. So the first part of does law matter is the question of just what law is, such that it might or might not matter. We can't ask the question, does law matter, unless we have some conception of what it is that would or would not matter. This is, to a significant extent, a conceptual question. But I want to at least make clear here that there is a difference from a conceptual question and the methods that we might use to answer a conceptual question. That is, if we are asking about what a concept means or just what a word means, one way of doing it is to sit in our armchairs and stare at the ceilings, stare at the ceiling. That's certainly a common method. It's not the only one. Kenneth Himme's recent work on coercion, with which I have considerable sympathy, makes clear that it might be useful if we are trying to talk about what a culture's concept of law is, to look at what that culture actually thinks, and so on. So I don't want to say any more about that, but except just to say that something is a conceptual question is not necessarily to say that it can be answered entirely with abstract, non-empirical introspection or speculation. Now, the reason that trying to answer the question, what is law, is important for the larger question of does law matter, is that this is a more or less interesting and important question depending on how broad or how capacious our understanding of law is. If we have an understanding of law that looks somewhat like Dworkin's, for example, such that the boundaries, if any, between law, morality, and some aspects of policy and some aspects of politics are somewhere between permeable and non-existent, then does law matter is tautologically true. And as it being tautologically true, it becomes less interesting. If law is everywhere, if there is no discrete thing, to use a non-technical term, that law is, then asking the question, does law matter, is not a particularly sensible question. And indeed, to some extent, the capacious understanding of law is an understanding that is allowed by so-called inclusive positivism. It is not demanded by inclusive positivism, but at least it is allowed by it. So a too broad, too capacious, too encompassing understanding of what law is may make it hard or pointless to ask the question, does law matter? On the other hand, if we have a somewhat narrower conception of law, somewhat closer to that offered by exclusive legal positivism, or a narrower conception that might be allowed, but again, not demanded by certain versions of inclusive legal positivism, then we can ask a somewhat more sensible question. That is, if law is only a subset of reasons, a subset of social sources, a subset of all of the things that will go into making a decision, then we can sensibly ask the question, does that subset make a difference to behavior? Does that subset make a difference to decisions and so on? So in that sense, the first part of my question, does law matter, requires some conceptual work at the outset. Second question. Having done a little bit of the conceptual work, then the second question is, how could it matter? That is, under what circumstances might what I have just referred to as a subset make a difference to human behavior, make a difference to human decision making, make a difference to human reason, and the like. Again, this is substantially or not completely a conceptual or possibly non-empirical question. So let me give a few examples. So one way in which law might matter is that law, this subset of stuff, this subset of things, might operate on other things. And here, most recently, we see the work of Mark Greenberg, but it has a precursor 20 years ago. Much the same thing was said by my former colleague, and I suspect Brian's former teacher, Donald Regan, when Regan talked about indicator rules, or law as serving an indicator or indicative function. He suggested that one of the things that law might do, one of the things that might help law make a difference would be the way it operates on the reasons that we otherwise have, the way in which it is an adjunct to, or whatever word we want to use to describe the way in which it does something with the reasons that we would have without law. It does something to the rational decision-making processes that we would have without law. It doesn't operate independently. It's not a reason by itself, but it might operate on others. I offer this just as an example. An example, as I said, of my second question, how might law matter? We could also add to possible answers to this question, Raz's service conception. Raz's service conception is largely of authority, and therefore of legal authority, is largely, let's call it a hypothesis. Raz might object to describing it as a hypothesis rather than an answer, but I'll put that aside. A hypothesis about how law and legal sources and legal norms might matter. So the service conception is one of them. And now I'll mention a quite different account of how law might matter. At least one of the less well-known Scandinavian realists, Willem Lundstedt, had a view that what law does is operate psychologically to create people's views about what is right and what is wrong. That is, that people's moral views, at least if one is, as Lundstedt was, a moral skeptic, one's moral views are not the identification of something that is correct, but rather they are psychologically produced by something else. And then the question is, what is it that might produce people's moral views? And Lundstedt, along with a vast number of contemporary American constitutionalists, believe that what law does is a significant factor in influencing what people believe is morally right and morally wrong. The answer to that question is empirical, psychological, at least again in American law. Gerald Rosenberg has been usefully skeptical about the view that what law does has a significant influence on people, on what people actually believe about moral and political matters. But again, this is all part of the question of how might law make a difference. Third, the question would be, does law make a difference? Does law matter? That is not to be confused with the second question. In far too much legal scholarship, there is a very quick move from the second to the third question. That is, deriving is from ought. And at least a common phenomenon in a great deal of legal scholarship is the fallacy of deriving the is from the ought. Once we recognize that this is a fallacy, we can say that whatever ought to be the case, there is an empirical question: does law actually matter? Here, of course, maybe I shouldn't say of course, but at least to me and some number of others, the significant area of thought and writing comes from the American legal realists. The American legal realists recognized that it was an empirical question about whether the stuff that we might call law, they were not themselves fancy legal theorists, but they presupposed that there was a subset of the universe of sources that we could call law. And then they said, traditionally, the assumption has been that that subset of social sources that we call legal sources actually matter to the decision-making of, in particular, judges and then derivatively lawyers. Many of the realists said for two things. One, it's an empirical question. And two, the answer is much closer to no than traditional legal thought has supposed. That is, that especially, again, they were speaking largely about the US and largely a little bit more broadly about common law systems, that law understood in this somewhat narrower way does not have a significant effect on legal decision making, does not have a significant effect on legal arguments. The best of the realists recognized that this was an empirical question that can be studied. The best of the realists recognized that just saying no is a little bit too simple, but that at least law, in the sense of formal legal sources, the kind of things you would find in a law library, the kinds of things that would be published by legal publishers, had less of an effect on less of a causal effect on actual legal decision making than the traditional view supposed. The more modern version of this, at least in my country, comes from the group of political scientists that tend to go by the name attitudinalists. That is the best predictor, they say, and they tend to study the US Supreme Court most predominantly, maybe too much. The most significant predictor of the votes of individual Supreme Court justices are the pre-legal political, moral, and social attitudes of the justices. There is a fair amount of empirical work that they've provided in support of that conclusion. But again, it's best understood as a modern version and maybe a more sophisticated and more empirically sophisticated version uh, of the original claims of the American legal realists. So if the first question is what's law, and the second question is how could it matter, and the third question is does it matter, then the fourth and final sub-question of the does law matter question is should it? Some, of course, say it shouldn't. These are the people commonly referred to as philosophical anarchists. I don't like the name. It suggests people skulking around at night in back alleys planting bombs in government buildings. That's not what we're talking about here. We are talking about the view that certain political decisions and certain legal decisions ought not to matter in people's making their all things considered best moral decision about what to do. Here, the significant names are my colleague John Simmons, Robert Paul Wolfe, a few decades earlier, and various others. The anarchists believe that the mere fact that some legislature, some judge, some king, some president, somebody has said something, even with all of the trappings that legal positivists would associate with it being made law, ought to have no effect on what we actually ought to do. That's philosophical anarchism. Now, of course, others say, yes, it ought to make a difference. This view has a rather distinguished history. It goes back to Socrates and the Crito. Other distinguished practitioners or articulators of the view post-Socrates would include John Locke, Thomas Hobbes, John Rawls, all of whom either because of reasons of say that because either of reasons of obligation or fair play or the social contract, actually the political decisions of judges and legislatures and kings and presidents and so on ought to matter in what we ought to do. In a more modern version of that claim, or one of the more prominent modern versions of that claim, is offered by Gerald Postema, among some number of others, saying that for reasons of coordination and convention and the like, there is a reason to follow the law, and therefore law ought to matter because it facilitates cooperative, coordinated social life. So those are my four sub-questions of the does law matter question. And having exhausted my time, I will just stop. Thank you.
Thank you, Fred, for this very intriguing presentation on the subject matter of does law matter. And now it's time to move to some of the prominent representatives of the continental legal philosophy, although working strongly in the analytic tradition. And this is almost the perfect introduction for Pierluigi Chiassoni, also one of the dear friends and colleagues of the Belgrade Law Faculty, and the one who has the opportunity in previous years to visit us, and hopefully we will, of course, have the opportunity to host him here. So, Pierluigi, the floor is yours.
Thank you very much, Miodrag. I wish to thank you and Bojan for having organized this event, which is so far very interesting. And I'm going to start with noticing that the question you posed as the basic question to this panel, what is the most important problem in contemporary legal philosophy, is not only momentous because it looks about the most important problem, but it is also ambiguous. And I'll pick up a different ambiguity from the one Brian picked up. And I think here the ambiguity is between a question asking for a piece of information or a question asking for a piece of direction. In the first case, the question is asking for an information about what, as a matter of fact, here and now is the most important problem of current legal philosophy. And this is clearly a question for sociologists of legal culture and sociologists in particular of our legal culture, our legal philosophy. But there is also a second way of understanding the question. As I said, it is a question asking for a piece of direction. In this case, the question commands an answer which belongs to what may be called prescriptive meta-philosophy of law, prescriptive meta-jurisprudence. In this case, the proper answer to such a question is to tell jurisprudence which problem should be considered by them as the most important problem. So here we have a piece of direction, a piece of prescriptive meta-philosophy of law. Now, in my presentation, I will take the standpoint of prescriptive legal meta-philosophy of law. And so my answer will be about what should be the most important problem current legal philosophy should cope with. What should be this problem? Well, I start by noticing that the age we live, a very busy age, but of course it is not only very busy, it is also and still, and for an immense number of humans, be they dwelling in the first or in the second or in the third world, it is a morally disgusting age. We have plenty of examples every day about the moral disgusting age we live in. I just pick up from my country the accident which occurred a few days ago, where there was a crash in a mountain vehicle, and 14 people died simply because the people who had to take care of the plant thought it was too costly to do that, and so they sacrificed 14 people to do that. So I think we are living really in the everyday examples of moral nastiness, of moral disgust are plenty. So I think that at the first blush, the first problem we jurisprudents should cope with is the problem of alleviating moral nastiness, the moral nastiness of our age. But of course, this is a very demanding problem, and in a sense, it is also a problem which somehow, if not properly dealt with, will turn jurisprudence into as many moralists, legal philosophers, social philosophers. This is not what we have to do. So we have to make this goal, this aim, this problem, dealing with alleviating the moral nastiness of our age, we have to turn it in a different problem. We have to cope with it in an indirect way. And so we have to identify a direct way, a direct problem for us. And now I think that if we look at the tradition of analytic jurisprudence on the one hand, and I would say the glorious experience of neo-enlightenment after the Second World War was ended, these two traditions, which of course are tightly intertwined, point to us the following problem, the following aim to be coped with. And it is, I would say that it is the promotion of a rule of reason, of a domain of rationality over positive law and legal thinking. The promotion making the positive law and legal thinking a domain of reason, something dominated by reason and rationality. This, of course, may look somehow perhaps disappointing task, but let me make some precisions about that, because of course, taken as a whole, this task, this problem, this aim is unmanageable. But as soon as we make a little bit of reflection, we may identify not fewer than 5 problems of detail, which are all concerned with the big problem of establishing the rule of reason over positive law and legal thinking. And these problems of details have to do with what I'm going to call the promotion of the rule of epistemic rationality, the promotion of the rule of methodological rationality, the promotion of the rule of conceptual rationality, the promotion of the rule of instrumental rationality, and finally, the promotion of the rule of substantive rationality. I'm going to say something about each of these goals, these purposes, these problems of detail. The first problem, the promotion of the rule of epistemic rationality, requires jurisprudence to basically father true and reliable theories about the law world. And this requires a double task. On the one hand, we have to work out, to continue to work out realistic theories of law, realistic general theory of law, theories of single parts of the law, adjudication, interpretation, legislation, etc. But on the other hand, this task of epistemic rationality also requires us as jurisprudence to take up the role of a legal epistemologist. I mean, we have to work out prescriptive discourses about the proper way of knowing, of scientifically knowing positive law. The second problem, the second task, is that of the rule of methodological rationality. Methodological rationality has to do with the way judges, jurists, and lawyers at large reason. And the task of jurisprudence is a task of controller and reformer. Here, the jurisprudent should teach judges, jurists, lawyers at large how to reason properly, correctly, by enhancing the knowledge and the master of logic and rhetoric. The third point is conceptual rationality. This is very important. And in a sense, it was always brought forward by analytic jurisprudence, but I think it's worthwhile to detach the work of conceptual rationality from epistemic rationality. The elaboration of general theory of law to the work dealing with the terminological and conceptual apparatus that at any given time is the medium through which lawyers, jurists, judges, etc., know the law, assume to know the law, and act within the law and develop practice. Here, the conceptual rationality requires jurisprudence a continuous task of refinement of the extant terminological and conceptual apparatus. The idea is that we should be distrustful of the extant terminological and conceptual apparatus, and we should think that there is ever room for moving from a poorer conceptual apparatus to a richer, more complete, more precise one. Here the key terms are clarification and articulation. We must get to more precise concepts. We must get to a larger set of terms corresponding to a larger set of more precise concepts. This is a big help to the rationality of legal thinking, because that means to replace bad terminological and conceptual apparatuses, not only of the central terms of jurisprudence, but also the central terms of the several sections of positive law, and replacing with clearer, preciser, more articulated ones. Think which progress we could have, for instance, in certain areas like criminal law or administrative law, if all the old, fuzzy, imprecise, biased concepts they still continue to use be replaced by a set of new, precise, articulated concepts. The fourth task, the fourth problem, is the problem of instrumental rationality, the rule of instrumental rationality. In this case, our task as jurisprudence has to be basically, again, a teaching task. We must instruct jurists to perform an instrumental analysis of existing laws at the national and international level in order to see whether they are rational from a means to end point of view. And finally, we have the task of substantive rationality. This, of course, is the more dubious one, but also perhaps the more exciting. Here, following a clue from Hart. Hart is the hero of Brian's presentation, and I agree with that. I agree that we must go back to Hart in many ways, in a sense. But it's very interesting that substantive rationality means establishing the rule of substantive rationality upon the law, positive law, and legal thinking, means that our task will be, in a sense, to check whether existing laws at the national or international level are acceptable from the standpoint of rational agents, meaning rational agents we are conscious of a self-interest, which is not necessarily a selfish one, and also they are conscious of their dignity of equal, free, and moral persons. So basically, these are how I propose you to understand the most important problem of current legal philosophy. We should fight, I might say, to establish finally the rule of reason on law and on legal thinking. Of course, this fight, we should also beware about bad ways of doing jurisprudence. Brian already mentioned this sliding back on metaphysical form of jurisprudence, this looking for essence, for the essential character of law, for the nature of law, for the fundamental nature of law. All these expressions are expressions which really bring us on a false way. I mean, we should get rid of that. We can quietly do our job without even mentioning words like essence, nature, and character. Okay, thank you very much for your attention.
If I had to bet before the presentation, thank you so much, Pierluigi. I would have bet that you are going to resolve some ambiguities, but I wouldn't have bet that you're going to find an ambiguity in the title of the presentation. So that was quite a surprise. So just before I introduce our next speaker, I would like to remind all the participants that they can, in fact, write almost freely in the comment or the chat, and they can ask questions. As mentioned in the first part, I don't know if everybody was here, we'll select some of those questions, and in the final part, Miodrag and I will ask the participants the questions that we choose. It has to be like this because of the interest, of course. There's 100 of us only on the chat, and probably some more people on Facebook following the presentation, following the conference. So if I went looking for the answer to the title question of the conference, Poland would be in my top 3 countries in Europe. And one of the reasons is that there is a peculiar, dependent on legal culture that was mentioned by Pierluigi, connection in Poland between legal practice and legal philosophy. And one of the representatives of this great connection and the living proof that you can do a fantastic job in both is here with us today. Unfortunately, not live on the faculty of Belgrade like Miodrag and I would like it to be, but this is the next best thing, the second best option. So Tomasz Gilbert-Sudnicki, the floor is yours.
Thank you very much for your invitation. That's really a great honor for me to be among such prominent panelists. So I really appreciate your kind invitation. I will be quite brief. I don't think I need a full 20 minutes. I will start with the following observation. Namely, Andrei Marmot noticed a few years ago that there's a widespread sentiment that the traditional debates about the nature of law have reached a dead end, not worth of further investigations. This sentiment moved some prominent legal philosophers to the view that legal philosophy, or rather general jurisprudence, is not interesting anymore and probably should be abandoned. I have in mind here the well-known paper by David Enoch. Of course, Marmot rejects such skepticism and claims that the general jurisprudence is in, as he says, no need of reinvention. Marmot believes that the subject matter of general jurisprudence is the nature of law. He claims that there are 3 main debates about the nature of law, answering 3 different questions. The question of ontology of law, the question of determinates of legal content, and the question of law's normativity, its ability to generate reasons for action. I'm not quite certain that Marmot is right. First of all, I'm not very enthusiastic about the concept of the nature of law. I quite agree with that, what Pierluigi said a few minutes ago. That is a very obscure concept. Usually it's said that the nature of law is a set of necessary properties of law, but it's unclear what necessity in the context means. And as Fred Schauer demonstrated a few years ago, there are certain features of law which are not necessary but important. For example, coercion is not a necessary feature of law, but we wouldn't be able to understand the law without taking into account that the law quite frequently is using coercion. So that is why I do not think that all questions about all legal philosophical questions can be reduced to the questions of about the nature of law as some of legal philosophers think. For example, Scott Shapiro, Joseph Ras, Julie Dixon, and few others. And obviously the question, is general jurisprudence interesting, should not be conflated with the question, is legal philosophy important? The answer to the first question is a matter of personal taste. It may be interesting for person A and not interesting for person B. Legal practitioners quite frequently say that what we are doing is terribly boring. But on the other hand, they admit that the findings of legal philosophy may be important for better understanding of social reality of certain social processes which law is involved. We observe certain phenomena in the social reality, and we are frequently puzzled. We ask questions such as how it is possible that, or what does it mean that. What we strive at is not so much scientific explanation, but rather understanding. So I think that the main purpose of legal philosophy is more hermeneutical than explanatory. Brian will probably not agree with me, but would like to say that explanation does not exclude understanding. So there are many links between those concepts. I'm not able to go into details here. So, I think that our desire to understand better drives us into legal philosophical inquiry. And I would like to raise only two issues. Those of you, I do hope that there's at least a handful of people who sometimes read my papers, I mean here my Polish colleagues who are present here, will be surprised because I will refer to such matters I never worked on. So I believe that those matters are interesting and important and require understanding and explanation, but that are not matters I ever worked on. That is my quite subjective selection, and of course I will list only two matters. Of course, this list is not exclusive. I will start with the following point. Mainstream of general jurisprudence is focusing on municipal law. It's quite obvious in Hart. Hart explicitly says that his theory is the theory of contemporary municipal law. The same Joseph Raz, he also says that he is interested exclusively in municipal law. Of course, neither Hart nor Raz deny that municipal law is the only form of the law they exist. They are quite simply not interested in any other forms of law. And here the problem of legal pluralism arises. The matter of legal pluralism is by no means new. Let me recall Eugen Ehrlich and his profound study of two parallel legal orders in Bukovina. Bukovina, that is a territory that before the First World War belonged to Austrian-Hungarian Empire. Now it's part of Ukraine. And on this territory, there was Austrian law imposed by the government, and there was local law. So two parallel legal orders were functioning the same time, in the parallel way. There's a number of books and papers on legal pluralism published starting from the second half of the 20th century, just to name Gunther Teubner, William Twining, and Brian Tamanaha. But all those books have been written from, I would say, sociological perspective. No much analytical work has ever been done. And I think that such analytical work is necessary. What initially the problem of legal pluralism, as studied by Ehrlich and others, was understood as parallel existence of two legal orders: indigenous law on a certain territory and colonial law imposed by the colonial power on the same territory. But today it's not anymore the case. Non-state legal orders exist globally. As Gunther Teubner says, we have global Bukovina. So there are certain non-state, non-municipal normative orders that are effective globally. We are subject to very many normative orders which are not products of any state, but are very similar to the state law and very different from morality. And those legal or those normative orders influence our social behavior sometimes to a bigger extent than the state law. Let me give a few quite obvious examples. Lex Beccatoria, the transnational law of economic transaction, that is quite a successful example of global law without a state. Then internal regulatory regimes or multinational corporations that influence lives of very many people worldwide. Then professional regulations, for example, for auditors, accountants, lawyers, doctors, and so on, created frequently without any intervention of the state. Then what is getting more and more important, regulations applied in various internet networks and platforms such as Facebook, that nowadays influence social life of very many people. Of course, this list is by no means exhaustive. What is common to all those types of rules is that, first, they have been created without intervention of state or only with a minimal intervention. They relate to important aspects of social life, and they are to a high degree formalized, unlike morality or etiquette. And fourth, they sometimes may be, but do not have to, in conflict with municipal laws. Of course, one may say the rules of all those types are not legal rules. They do not fall under the concept of law. But that would mean that would be quite a risky answer for legal philosophy, as this answer would imply that general jurisprudence is not interested in certain phenomena which for many people are indistinguishable from law. And here a few fundamental questions arise. For example, is the conceptual apparatus of general jurisprudence, analytically oriented positivistic jurisprudence, sufficient to deal with those problems? Can the non-state law be explained and understood in terms of the rule of recognition, primary and secondary rules, preemptive or content-independent reasons? Is the relation between those regulations and morality the same as between state law and morality? To my knowledge, all those questions remained unanswered, or as far as I know, very not much work has been done in this area. So that was my first point. My second point refers to different issue, and namely to social ontology of law. Again, this topic is by no means new, but in the most recent years, the social ontology has gained increasing attention of general jurisprudence. There is increasing number of publications of law as an artifact, including quite a recent book published, edited by Luca Burazin, as far as I remember, Ken Hima and Corrado Roversi, with chapters authored by certain participants of this panel. Social ontology of law is certainly a fascinating topic, and there's quite a lot of very controversial questions. But I'm mentioning this point for a specific reason. Social ontology of law is not only a philosophical problem, but it has many practical implications, which in recent years become more and more important. The question is whether the social ontology of law may help us to deal with certain new legal phenomena. What I have in mind here are, in the first place, certain new categories of non-human legal subjects. I mean here, for example, software agents. To my knowledge, they are responsible for 99% of trade that was at the New York Stock Exchange. Then I mean environmental legal persons, such as rivers and mountains. Then I mean animal species in connection with the discussion on human rights. There are probably more categories. Each of those new categories is very different and triggers quite a lot of problems. One thing is certain: traditional juristic theory of legal persons, there is a certain misunderstanding between continental and Anglo-Saxon jurisprudence. In continental jurisprudence, legal person, but is a corporation or foundation. Human is a so-called physical person. But when I say legal person, I mean the total category and not only corporations and alike entities. So I don't think that the existing theory of legal persons are fully applicable to those new types of legal entities. They trigger quite a lot of problems related to fundamental legal concepts such as liability, action, right, claim, privilege, and so on and so on. The question is whether what to do. So how we should improve our analytic categories in which we so far described legal entities in order to cover also those new entities. Thank you for your attention.
Thank you, Thomas, for the presentation and for bringing up definitely two very important issues, at least quite dear to myself, since I did, if I may use the opportunity and privilege of a moderator to emphasize that I did write a couple of things on, for instance, global law issue and on the matter of collectives as holders of rights. So this is definitely in the area of two questions that you brought up. With this, we move to the fifth participant in the panel, our dear friend and colleague Torben Spaak, who was also supposed to be our guest in what we envisaged as the first Jurisprudence Jam session. That was the official title of our meeting that was supposed to be organized exactly on the day when a state of emergency was introduced in Serbia due to the pandemic of COVID-19. So since we did not manage to bring him here last year, at least we have him here right now. Of course, again, one very important tradition in legal theory, Scandinavian region with well-known theories of legal realism. And Torben, the floor is yours, and hopefully you will manage now to share the presentation with us.
Thank you very much, Miodrag. Thanks so much for inviting me to this event. Let's see now if I can. I want to make use of a PowerPoint. Let's see if I can handle this.
Perfect.
Yeah.
Yes.
Yes, that's it.
That's it.
Fantastic. Let's see if I can move it too. All right. So I will begin. The most important problem in current legal philosophy. Well, that's a big one, and I hardly feel qualified to speak on this topic. But I'm going to suggest that that it is. You know, I like Pierluigi, I take this in a prescriptive sense. So I'm giving you my view about what might be worth our while. It's not a command, of course, just a suggestion. So the problem, as I see it, is to focus a little more on legal reasoning. And I add here to choose a general philosophical framework within which we can do this. And here I'm thinking mainly of naturalism, but you could, of course, be a non-naturalist as well. Let me just show you this hope it's not too unclear here. So when it comes to naturalism, I want to begin with this, say a few words. So you have ontological naturalism, you have epistemological, or as they say, methodological naturalism. When it comes to the ontological version, you have physicalism for one, and you have some espouse then a more liberal conception of nature, you know, not just physical entities, but something else. The epistemological version then, and here I'm following Brian, who many years ago now, I think, made a distinction between results continuity naturalism and methods continuity naturalism. And I've underlined what I believe most in. There are so many questions here that I will just very briefly state what I'm inclined to believe in. Everything here can turn out to be mistaken, of course. But I would accept some version of ontological naturalism. Probably, I'm drawn to physicalism with a more liberal conception of nature, because I feel that otherwise I'm undermining myself sooner or later. When it comes to epistemology, the epistemological version, I would stay with the results continuity version, which says that, as I remember, Brian wrote that you have to, you have to keep your philosophizing or your philosophy in line with the results of the sciences. More popular, and I think this is what Brian believes in, if I recall correctly. Anyway, it's the idea that philosophers should adopt the methods that is fine. Now, this I'm a little suspicious of for two reasons. First, it seems to me that if you did this, you would change philosophy into let's say sociology or some other science, which I'm not particularly keen on. The second thing is that I'm worried. I don't want to get rid of, I don't think you should just rule out a priori justification or a priori knowledge. Question is, of course, what can you have such knowledge of? And I would say, laws of logic, reasoning generally, inductive reasoning, for example. I wonder if you can justify induction. The kind of framework that I have in mind there would be a weak, I call it a weak naturalist framework, which I'm always willing to give up should I find that it's not working. But a combination then of ontological naturalism and what Brian calls results continuity naturalism. And I leave many things open here. Having said that, I will say something I actually made an effort here to say something about philosophy. I don't really have a philosophy. I tend to do the first possible sense of the term, hang together in the broadest possible sense of the term. You may fairly wonder, what does this mean? And I think it certainly opens the door for conceptual inquiries, I can say. But generally speaking, see how thesis, concepts, and what have you, that you tend to endorse right off the top of your head, and see how they can be combined, if possible. So I would say that my conception of philosophy in general, vague though it is, includes a lot of conceptual analysis and explication, but not only that. I'm open to metaphysical and normative evaluative inquiries and more. I don't want to rule it out. And also this here, I just mentioned about naturalism. I call this an adequacy constraint. And it's a weak one. It's very tentative, the whole thing. But as I said, I'd like to at least start out from something like ontological naturalism combined with epistemological naturalism of the results continuity type. Should I run into a roadblock, I will have to rethink that. But that's roughly my starting point. Legal philosophy then, and here I'm using an old map drawn by Hart, actually back in the 60s, but I think I like to think it works. And so here you distinguish between the analytical part and the normative evaluative part. And in the analytical part, which is what I've been mostly concerned with, you have, of course, the question of the nature of law. You have the analysis of basic or fundamental concepts, and you have the study of legal reasoning. And what I'm saying is that even though the question of the nature of law quite clearly is a fantastic question and the foundation, I think, of everything, I'm beginning to think that, at least for the moment, we're getting diminishing returns, if that expression works in English, that we expend a lot of energy, but perhaps the results to my mind, don't seem to really stand in a reasonable proportion to the energy expended. So my suggestion is simply, let's focus a little more on problems of legal reasoning. And I think, I could be mistaken, but I think this is in keeping with what Pierluigi said earlier about methodological rationality, or at least I hope to get some support in that corner. So let me now simply give you 3 examples of problems of legal reasoning that I myself find interesting and worthy of further investigation. I wouldn't, of course, argue that these 3, or one of them, is the biggest problem of legal philosophy, but I think there are worthy of, as Fred so wisely said in the beginning here, one tends to, and certainly this is true of me, when I say it's the biggest problem or a big problem or an interesting problem, it's what I'm working on. I'm sorry about that, but I can't help it. It's a matter perhaps of how you, of your, how much of an overview you can take of an area. And I tend to be bogged down here in my own interests. But, so here's what I have. One that I've recently found is simply a theory called reasons-holism and its possible application to the law. So reasons-holists, and I'm thinking of Jonathan Dancy in particular, argue that reasons, whether it be theoretical or practical, reasons for action, reasons for belief, needn't have the same force or polarity in every situation in which they appear. And if reasons-holism is true, there can be no true general norms, because the norms would have to be formulated in terms of the reasons. But if the reasons can change both force and polarity, direction, that is, from one situation to another, then it's difficult to understand, well, law or morality or whatever in terms of general norms. And that, of course, is why Dancy defends moral particularism. I'm more of a generalist myself, but I find that this question raises so many interesting issues. And for us, of course, it's interesting because we obviously think of law in terms of general norms. We emphasize the importance of uniform law application. We say, or they do say, at least in the common law countries, that the ratio decidendi of a case is the general norm without which the court couldn't rationally have decided the case the way it did. And there is, of course, more. But you may wonder now, okay, so reasons-holism, what does it have to do with law? And that is a good question. The first question, I mean, why should you believe it? Of course, I'm not saying reasons-holism is true. In fact, I doubt it myself, but I'm not sure it's false. And it is, as I said, interesting. So why should you believe it? Well, Dancy gives us a number of examples that simply are meant to show that the opposite view, reasons atomism, which many of us, I think, find more natural, is flawed. And he also points to another, I think, where he had a problem with the usual understanding of reasons, namely that we in order to maintain the idea that a reason has the same force and direction in all situations, it can be outweighed sometimes and not in other times. But then we have to specify. We're on a never-ending quest of specification, which will the print or the reason and the corresponding norm very difficult to handle. So, but then let's say, for the sake of argument, that it is a defensible position. Then, would it apply to the law? Well, that depends on what we should say of legal reasons, because this idea, then, reasons-holism, is a theory about genuine reasons, as they call them, or real reasons, not conventional or institutional reasons, where an institutional reason is a reason for you if you have accepted a certain institution, such as law or etiquette or something. Whereas a genuine reason would be a reason that applies to you and has forced you think or do or consent to. So that's the general idea. And then the question, of course, is, well, is law a matter of are legal reasons genuine or are they conventional? If you're a legal positivist and you endorse the separation thesis, you will they must. So then you could get rid of the problem. But if you don't accept if you're a non-positivist, if you're like Dworkin or Michael Moore or Mark Murphy to Mark Greenberg, then you will reasons as genuine, as far as I can tell. And then if you believe in reasons holism, you will find yourself in a problematic situation. And it's worth noting that even legal positivists could reason and say that, well, as far as interpretation and application of the law, legal positivism doesn't really apply there. And so the reasons there might be genuine reasons in that field. And so the problem and that in turn gives rise to many further difficulties. I found it simply very fruitful. I mean, thinking of this, it keeps on giving, as they say. Second thing, legal statements. I've always been interested in legal statements. If you think of legal reasoning as really consisting of premises and conclusion, and they're all legal statements, then you should probably, or I think you should make a distinction between first order normative ones and second order descriptive ones. The second order ones would be according to Chicago law, Illinois law. But first order ones would be propositions of law, normatively the content. But if you go with the first order ones, you have the distinction that you find in Rass and in Hart between committed and detached legal statements, which both are normative, though the committed ones are the ones where you speak your meaning, sort of. You mean what you say, but the next one are when you don't do that. You maintain something that you don't believe, that you don't accept. You may, for example, be an anarchist and speak from the point of view of law. And the question now, maybe there are further types of legal statements too, but in any case, you want to analyze these types of statements, and especially the normative, the first order ones. And then you're likely to find the usual metaethical theories. Would you adopt a fictionalist or a non-cognitivist, a constructivist relativist, perhaps, or are you an error theorist or a cognitivist, a non-naturalist, for example? And this, of course, is a very difficult question. But there is also the possibility that you could say, well, law is really not morality. Law has a certain special features, and so you need some sort of hybrid theory. Perhaps something like the one that Hart appears to have espoused. So here, and in all this, of course, you have to take into account the application of the laws of logic. I mean, you do want to, or I assume you want to portray legal reasoning as a rational activity. But if you're a non-cognitivist, you have the Frege gauge problem, and then, well, there are many issues, of course. Let me know. I'm beginning. Boyan, how am I doing on time? I'm better.
I'm turned on. It needs a bit time. So you're doing fine. We have at least 7 more minutes.
Okay, very good. Has to do, you look at legal thing is deductive, common law reasoning is inductive. And I mean, it's been said. And then you wonder, is that so? Well, for me, it's easier to think of I begin with deduction, to think of reasoning as having a deductive structure. And then I would say, what must do? Here we have in the background, of course, the other problem of laws of logic and norms, or normative statements. But then it's equal capacity to formalize legal language and apply logical reasoning or the theories. And here I want to emphasize the second thing here: apply, because what the logicians tend to do, and logicians in general, they tend to discuss meta questions. They focus on a given system of, let's say, the deontic logic and discuss paradoxes and stuff, but they rarely apply that. I would forget moment and assume pieces are, that's what I, but I think this thing of logic to legal reasoning, I think is should be done by people who can do it. Induction is also interesting. Let's say that you accept the enumerative induction, analogy, and the best explanation. It's supposed to be a paradigm case of inductive reasoning in common law jurisdictions. But is it really? I wonder. I think do with a doctrine. Precedent that then you're wondering, should I go with the purpose or with the plain meaning? And one way, of course, of deciding this is to invoke a general norm, which, let's say, prioritizes plain meaning. What is there? A piece of reason here. One come back actually to the question of reasons holism.
Sorry for interrupting you, Torben. The video has become increasingly choppy now in the last couple of minutes, and I'm afraid that all the things that you want to say won't come true. I'll try this, and I thank Ken Ehrenberg for suggesting it. I'll try to turn off just your video, so we'll be able to hear your voice and see your presentation, just as a heads up. So could we try this?
Okay. So just repeat this last part on
if you could,
on 3B.
Yeah, on 3B, repeat the last part after I stop the video. It would seem that it's something with your connection, and it might ease it up if I stop your video.
Okay.
Let's try it now.
All right. So I was simply saying that as for induction, if you look at these examples, I said that if you want the paradigm case of inductive reasoning is supposed to be the extracting of a norm from a series of cases, and I said that I don't think this is inductive reasoning. It's a matter of you have to look at what the relevant doctrinal precedent says. Determining the ratio identity, what's that? Is that an inference to the best explanation, or is it perhaps the usual disjunctive syllogism? And finally, what I really think is interesting is the weighing of interpretive arguments. When you weigh, let's say, a textual against a teleological consideration, and you do that without invoking a general norm that would, let's say, prioritize the plain meaning for predictability reasons or something. But you make a choice, and the question is that a piece of reasoning at all? And it seems to me that here you might come back to the question of reasons holism, if you believe in that, where you simply say that I'm not using any general norm, so there isn't the case of deduction. What I'm doing is simply weighing. I'm looking at things, and I see that the one reason carries more weight than the other, and I decide accordingly. So the point of what I'm trying to say here is that if you look closely at certain pieces of reasoning and try to pigeonhole them and say, is this deductive or is it inductive? And if so, how? And if it isn't, what is it? Is it simply a choice? So I think that's interesting too. There are many, what I'm trying to say, of course, finally here is that there are many things, much you can do once you look at legal reasoning. And so my recommendation would be then that we do perhaps a little less, at least for a moment, of the nature of law stuff and a little more legal reasoning. Thank you very much.
Thank you. It was far, far better when we turned off the video. Thank you for your presentation. And with the end of Torben's presentation, we come to an end of the first part, in which every one of the panelists had their 20 minutes for presenting. Now we come to this second part, where each and every one of the participants will have 5 minutes each to reflect on the issues raised by other participants. This is also a part where we will go in the same way. So Brian, Fred, Pierluigi, Tomasz, and Torben. If there are some questions that are addressed directly to you, I will of course mention them. Just before we start with this part, I would it will take a couple of seconds to unmute you all, so we don't have problems with this. First, Brian. Okay, Brian has the request to be unmuted. Okay, then Fred. Pierluigi. And Tomasz. Okay, now if everybody is unmuted, we can start. Brian, there was...
Oh, yes, okay.
Everything's fine.
Yeah.
There was a question addressed specifically to you, and now for the participants, I'm just sorry in advance for horrendously mispronouncing your names, but that's quite the usual thing. Cristiano Moita asks, and the question is posed for Brian, could you comment on the relation of some of your other interests, especially when it comes to philosophy, since you were very interested in, for Brian, you are very interested into non-standard approaches to philosophy, for example, into Nietzsche's philosophy in relation to philosophy of law. Does it have any bearing, or can you see it having any bearing on the philosophy of law?
Okay, well, thanks for that question. This may be more intellectual, autobiographical than is interesting for most people. My way into philosophy of law was largely through legal realism, which I studied with Fred Schauer many years ago in Michigan. And of course, it was a funny way in because legal realism had kind of a bad reputation in legal philosophy, just like Nietzsche had kind of a bad reputation in Anglophone philosophy. There are similarities between those two interests of mine that operate at a very meta level. That is, I do actually think Nietzsche is a certain kind of philosophical naturalist, contrary to, I think, the scandalous misrepresentations of him by Heidegger, by Derrida, and by other authors, Alexander Nehamas, in the Anglophone context. Just as I think you can make better sense of a philosophical point of view of the legal realists if you understand them as having a kind of naturalized conception of what jurisprudential inquiry is. So that I think is the main similarity. Now, of course, Nietzsche has some quite radical substantive views on questions about, say, moral responsibility and freedom of the will, and skeptical views about moral responsibility and free will do, I think, have implications for significant parts of the law. But it hasn't been really a focus of my work to try to think about what those are. I would say my general view, this is also part of Nietzsche's view. Nietzsche's view is that our human existence is heavily dependent on illusions and falsity. And I think that law should probably proceed relying on its illusions and falsehood and not pay too much attention to Nietzsche, because things could maybe not work out so well if that happened. So maybe I'll just leave it with that, so as not to go too much further into what Nietzsche's views are. But thanks for asking that.
I mean, Brian, you can use this also as a, as a time for the reflection on other comments if you like to add something.
I'll be pretty brief about that because the other four speakers covered such a wide array of topics. I mean, it did seem to me that Fred's basic question, does law matter, turns out in its four parts to encompass all of legal philosophy plus a good deal of political philosophy. So if the goal is prescriptive, Fred is entirely successful because we're all, in fact, doing some piece of his four-part project. I will say about Pierluigi, and this kind of surprised me because I thought all my friends in Genoa were moral anti-realists. So when I heard that the rule of reason was to take over for law and that laws were to be assessed in terms of their substantive rationality. First of all, I don't think there is such a thing as substantive rationality, and I guess I'm surprised that Pierluigi does. Does Ricardo know that you believe this?
I tell you later.
But I do wonder whether the program that Pierluigi sketched doesn't go well beyond what I would think of as any distinctive competence of people who do legal philosophy, especially when we get into the domain of questions of substantive rationality. As I say, I don't think there is a substantive conception of rationality. I think the best conception of rationality we have is the instrumental one, and even the instrumental one isn't rational obligatory. Which follows partly from the fact that there is no substantive conception of rationality. And I think I'll stop with that. I mean, I'm not, as I say, I'm kind of sympathetic to things that Tomas and Torben said. I think there is a lot more work to be done about legal reasoning. On the other hand, I think it's important to be clear that legal positivism isn't a theory about legal reasoning. So there's, it's important to keep those, I think, conceptually distinct. And I think Tomas is right. There's quite a lot of work that could be done. A lot of the work that travels under the heading of legal pluralism is a complete conceptual and analytical muddle. And I never have any idea what these people are trying to say. And I think Tomas is right that there's work that could be done here that would actually be helpful in helping us understand what non-state forms of law are like and what, if anything, they all have in common. So I'm sympathetic to those as research proposals. I think I'll leave it at that for now.
Thank you, Brian. We move on to Fred's comments, and there is also one of the questions that we picked up from the audience, from the participants, and Bojan will read it. It's specifically addressed to Fred.
Motoki Miura so asks, and to shorten things up, the question to Fred is, if there is a relation of priority between the questions, between the four questions that Fred found central in his talk, especially given his work in the fourth law and playing by the rules. And if there is a relation of priority, how can it be reconciled given the internal and external point of view?
Okay, so thank you for that. I'm not sure there's a priority. I talked about four different sub-questions of the big question in terms of what different people think of importance and what different people work on. The fourth question is the one on which perhaps I have the least amount to say. I am most interested, I suppose, in the second and third, the empirical part of whether law actually makes a difference, and in terms of my own work, force and coercion, in how could law make a difference. The grand moral question of philosophical anarchism and whether it ought to make a difference and so on, I find interesting and important. It's not so when you say priority, I don't want to say which is more important. All I will say is that perhaps the second and third are more important to me. I've been less involved with the first, the conceptual question, and less involved with the last. The second and third are more important to me. One thing you asked about the internal point of view, I think it relates in an interesting way to my third point about empirical inquiry. I think when Hart talks about behaviorism, when he talks about legal realism, when he talks about the legal realists or empirical inquiry as ignoring the empirical, ignoring the internal point of view, I think he makes a big mistake. I think there is a difference between what the internal point of view is and how we would find out about what somebody's internal point of view is. And those who do behavioral inquiry about law, at least at their best, are not trying to say that there is no internal point of view. They are not trying to say that the internal point of view is non-existent. What they are saying is that sometimes the best evidence of what somebody's internal point of view is what they do. Hart, although he is dismissive about what he calls external empirical inquiry about the internal point of view, doesn't really tell us how we should find out what somebody's internal point of view is, except he sort of hints that we ought to take their testimony at face value about what their internal point of view is. It's not clear to me why we should do that. Somebody's testimony about what their internal point of view is one piece of evidence about what their internal point of view is, but so too is what they in fact have done. There are lots of different forms of evidence, and we shouldn't confuse the evidence of what somebody's or some institution's internal point of view is with the internal point of view itself. In lots of different areas of inquiry, the sort of ontological question, what is, has to be understood as different from the epistemological or evidentiary question, how do we find out about it? And to say that we can often use external evidence of what someone has done as some evidence of what they have internalized is not a contradiction in terms. Let me just say one more thing while I have the floor. I certainly agree with a great deal of what Torben said about thinking about legal reasoning from a philosophical perspective. It may be, there are certainly branches of Anglophone legal philosophy that have assumed that the only useful form of jurisprudence, or the only thing entitled to the term jurisprudence, is so-called general jurisprudence. I don't want to be a linguistic arbiter of the term jurisprudence, especially since it has such a different meaning in continental terms than in Anglo-American terms. Let me just say that, at least for me, and I think for Torben, using philosophical tools to think about how lawyers and judges reason and argue and decide is a very important enterprise. It's not general jurisprudence. It not being general jurisprudence does not make it less important. It is, in my view, a mistake to think that the domain of legal philosophy ought to be exhaustively occupied only by general jurisprudence. So I'll leave it at that.
Thank you, Fred. Pierluigi is next. There is a question for Pierluigi. Actually, I was thinking about addressing this next question to both Pierluigi and Tomasz. Given the nature and topics of their talks, and I somehow sense their respective answers. But the idea is this: and it's posed by Michal Araskevich. Do you see a way in which the tensions, traditional or recent tensions in philosophy of law, dichotomies practically, between naturalistic, for example, non-naturalistic, analytic, and hermeneutical approaches, has the tendency to resolve in recent philosophy of law?
Sorry, I missed the last part of the question.
In which ways are the debates between for example, naturalistic and non-naturalistic, as well as analytical and hermeneutical approaches going? In which general direction? Which ones of them you find more appealing or dominant going forward?
But, well, I think, for instance, from the standpoint of an analytic way of conceiving jurisprudence, surely I'm for, I think, the naturalistic approach. I mean, the denial of the idea of a first philosophy, I mean, in this meaning, of a first philosophy which would bring us to know, discover necessary truth about the law, that's no place going. I mean, so I think analytic philosophy is a sort of servant to a naturalistic epistemology, to a naturalistic conception of knowledge. Clearly, the only sound knowledge is empirical knowledge, and all other sort of course, we can also consider, of course, formal knowledge, but this mysterious idea of a first philosophy dealing with the essences and nature of things should definitely be rejected. As to the hermeneutical approach, of course, there are many different hermeneutical approaches. So I would like Michael to clear what he has in mind by this. Not necessarily an hermeneutical approach is at odds with an analytic approach. In a sense, Hart, for instance, can be sensed to use hermeneutic approach to precisely in his notion of internal point of view and this idea of the internal aspect of rules. So the idea is to understand. He also, I mean, emphasizes the problem of understanding what we think to know. So if this is the hermeneutical approach you have in mind, I think there's no problem. If by an hermeneutical approach you think an approach which consider some form of interpretation, so far as the law is concerned, as a way of knowing the true meaning of legal provisos, for instance, I think this is pure ideology. So from that point of view, it's a practice that should be demystified. I don't know if I have answered to your question, Michael, and if you have some follows up, please, I'm here to hear it, to try to cope with that. As to just a general comments to my friends, I've already said that I share Brian's standpoint on certain ways of doing legal philosophy. And now he raised an objection to my idea of substantive reason. Well, first of all, as you may have understood, the enterprise of jurisprudence as committed to the goal of the rule of reason on law and legal thinking, this goal turns jurisprudence in a mixed enterprise. It is not only a matter of descriptive, explanatory, or expository jurisprudence, but also it takes up roles which belong to normative, sensorial, prescriptive jurisprudence. Clearly, the idea of substantive rationality, which I admit, I just mean by substantive rationality what can be imagined as the ethical normative reflection of reason, of the values connected to reason. So if the value connected to reasoning is that reasoning should be between equal people, equal persons, which are equal moral persons, that we are free, because if you are not free, you can't reason. So if we build this ethics of reason out of the practice of reason, I mean, Alexei, for instance, I think is an example of that. But clearly, I'm not claiming that substantive reason is an objective ethical position. I'm just saying that if we follow this idea of establishing the rule of reason on the law, another clue, as I said, comes from Hart. Hart thought that critical jurisprudence should come in two stages. The first stage is precisely the critical evaluation of a legal system from the standpoint of the rational agents. The second stage is from the standpoint of different ethics, perhaps one may say more robust ethical attitudes, ethical standpoints. I think that if we somehow go deep into the idea of substantive rationality as the ethical side, ethical dimension of reason, then here we find a quite robust ethics, because I mean, still now claiming that every individual has equal dignity and is an equal free moral person is not something
We lost your volume, Pierluigi.
sorry. In a lot of places in the earth, this idea of equal dignity of people is by no means the rule. And we know plenty of that. I really admire Fred's approach, because his idea of putting on the center as the basic, the most important problem, does the law matter, is a clear use of what I call the principle of ignorance, in a sense that, of course, the law matters. But I think, from a standpoint of the man of the Clapham bus, I am there. I'm of the Clapham bus. Clearly, the law matters, but of course, we must, as jurisprudents, also ask these questions, which presuppose we forget what we know, what we assume to know. And so we try to understand what we really think to know. So this is really something I share too. And of course, I agree with Thomas' program that surely we must move to a larger, a wider notion of positive law of legal phenomenon, going beyond the municipal law or international law in the traditional way, and taking into account all these sort of things which, as Thomas has rightly said, challenge our conceptual apparatus. They push the borders of conceptual apparatus farther. And finally, of course, Torben's proposal of a branch of focusing as a problem, as a very important problem in jurisprudence on legal reasoning. Well, I think I, of course, agree. Indeed, the methodological reason, the rule of methodological reason is precisely making legal reasoning something which is, for which reasoners are accountable to legal culture, to other jurists and judges, making almost impossible to resort to argumentative fallacies and teach judges how to write properly a piece of reasoning by, for instance, bringing to the fore the logical structure of a reasoning and then clearly complementing each independent premise of a logical inference with adequate external justification. So I really agree. I have just a question. Torben mentioned metaphysical reflection or investigation. I would like to know what he means by that. Thank you very much.
Thank you very much, Pierluigi. We move now to Thomas' comments, and there is one question which was posed by Gabriel from Peru, and I think you might be a proper address because he basically mentioned a part of this new social ontology, so relying on the means of artificial intelligence more and more, and how this might reflect, if at all, our understanding of reasoning in law. So what might be your response to this problem? And of course, be free to comment on other issues that were raised so far.
Well, I'm not quite certain that I'm a good addressee of this question because I don't know much about reasoning, but certainly, well, if you have a software agent, you must make it possible for such an agent to make certain reasoning. So maybe Torben will be able to answer this question better. But thank you for the question. I will be very brief, just two very short comments. First comment to Brian. I'm waiting for opportunity to discuss with Brian the problem of rules and practices and the problem of metaphysics of law. That's not a good occasion to do that now. Brian, you promised to visit us in Krakow. I hope it will be possible soon and you will keep your promise and come. And to the question that is relating to hermeneutics, I quite agree with Pierluigi. I also believe that what Hart did, that Hart had a hermeneutic purpose. We understand law much better after having read the concept of law. And I think it's quite clear in Hart. It's also the same, I think the same applies to Joseph Raz. He said that what we are doing when studying the nature of law is the concept of law is we are studying our self-understanding. So that means that his purpose is to bring about better understanding of certain social phenomena. I may be wrong, but I don't think that explanatory and hermeneutic purposes are mutually exclusive. So it's not so that legal philosophy can do only the first and then it's prohibited to do the second. I think if all that may be combined, that depends what questions are we asking. So thank you for your attention.
Thank you. Yeah, thank you so much, Tomas. And our last speaker, Torben, also a question for Torben, directly addressed. Should one, by Diego Moreno, should one, for the purposes of philosophy of law, formulate traditional problems in psychological terms so as to formulate hypotheses that could, in principle, be falsified, especially in relation to the normativity of law, given the difficulty in reducing normativity to psychological and physical facts? Torben, you would have to accept my now everything should work perfectly.
Yes, thank you. Well, since I said that I endorse at least some weak form of naturalism, I suppose I should answer your question in the affirmative, saying that yes, that's what you should do. But I'm not sure actually. I feel that maybe that I'm contradicting myself, but I wouldn't insist on that. That would be my first choice. Go with the psychological conception, whatever that might mean exactly. but to see what the results are. It's certainly, I'm always prepared to, I mean, I start out from a naturalist standpoint, as I try to explain, but I can give it up if it seems that the results are counterintuitive or just plain unilluminating. I think I would simply give it up. It's very hard to say, but I would begin in that way.
Oh, wait. Please, Torben, feel free to comment on the other speakers' topics and talks.
Yes, I should begin. I should begin, I think, by answering Pierre Luigi's question. Can you hear me?
Yes.
No. Well, what do I mean by metaphysics? Well, that's a fair question. In the first place, I mean, well, simply, here I follow Frank Jackson in his book, From Metaphysics to Ethics. Simply that you adopt the naturalist stance and then you try to account for whatever you're interested in, whether it be semantical or mental notions in terms of this underlying theory. That would be a metaphysical enterprise. But as I said, I tend to be liberal. I wouldn't rule out even other approaches. I would have to take a look at them. But I guess my as I said to in my answer to the question I dealt with a minute ago, that would matter here. I would begin with a naturalist position and see how far that takes me. I imagine it could be that it doesn't take me very far, and in that case, I would have to think about what I should do. But my short answer to you, Pierre, metaphysics on a naturalist basis, kind of like Jackson does.
Thanks.
I had a couple of questions of my own. I was intrigued, Brian, when you mentioned Gilbert Ryle. It never occurred to me. But just so I understand it, what's your point here that Hart was inspired by Ryle's behaviorism, and that is the reason he doesn't want to impose any contemptful constraints on the internal point of view. Count as a bona fide internal point of view, whatever, I mean, a normative point of view, whatever the underlying.
That's roughly right. Let me put it a little differently, right? I mean,
Yeah.
Hart says that the evidence that people take the internal point of view is entirely in terms of what they say and do. It's all behavioral evidence, right? They criticize the deviance from the social rule. They justify their own behavior by the rule. They say they must do this. You ought not to deviate, right? So it's all behavioral evidence of the internal point of view, right? And I think I think the reason he's taking that approach is because of Ryle's in the background. I don't think that he's got like a principled commitment to Ryle's general philosophy of mind, but I think he learned from Ryle the idea that behavioral evidence is for ascribing attitudes to people we call mental states. And the problem is, I think that has led some people more recently to think that because we don't operate with Ryle's constraint typically. We think that if you say someone has an internal point of view, you're saying something about what's going on in their head, right? How they're experiencing things, what their attitudes are. And because of his Hart's Rylean way of doing this, it suggested to people that you could adopt the internal point of view. In fact, your point of view is basically, I'm just collecting my paycheck, but I'll talk the talk and walk the walk. But it's not really, right? I don't in any real sense believe this is obligatory, right? Now, I think there are other reasons in Hart's theory to think that the attitude of the internal point of view does have to include a kind of stronger commitment on the part of the agents. My point today was only that it's been obscured or confused by this Rylean prejudice at work in the way Hart approaches this.
Is that no? Thanks. I just when I listen, it came to my mind, you know, Fuller's insistence that it has to be a substantive point of view. It's not good enough just to, I mean, they didn't speak, and so he didn't mention what you just said, but simply the idea of imposing a requirement about on the content of that. That's why I connected what you said to that debate, but there may, of course, be several reasons for said what he said. I was just curious. I mean, interested to hear that. Let me see now if I had any. Again. Yeah. Are you saying anything, Brian? No?
I said we lost you there for a moment. We lost the audio at the very end of what you were just saying.
Okay. That wasn't important. I'm looking in my papers. I think I wanted to ask Thomas a question here. He spoke of non-state law and all that, and at first in my presentation I had wanted to speak about that, but then I realized I couldn't say everything I wanted. But what I wanted to say about the nature of law is, I think there is a good reason to look at electoral and all that, and to see what. I was drawn into that some time ago, but then I got somehow dragged back into the usual stuff. So I have unfinished papers about non-state law and that. But it seems an interesting question to sink your teeth into.
Yeah.
What did you say about that?
Quite frankly, I've never worked on that, but I did quite a lot of reading, and those what exists in the literature of the non-state law, well, has a very, very different quality. You know, there's some very good stuff. Gunther Teubner, that's really excellent, but of course he's not analytic legal philosopher. He's a sociologist, but what he's writing is really very interesting. Then that is a big book by William Twining, very interesting as well. Maybe I would not mention those books that I do not like so much in this review, but the quality of literature on this topic is very different. So for me, it's only, you know, I don't think I'm able to do any serious work on that. The topic is interesting, therefore I'm doing some reading.
Okay. I was just curious. No, I think the questions I had, I lost Fred at the end. So but otherwise, no. It was very interesting to listen to all of you. I'm finished.
Thank you so much. I'm sorry for all the attendees, the participants, if we haven't been able to ask all the questions that were posed. It has to be a matter of selection, since we are not here in person, and this is one of the ways to pose as many questions as we can. Hopefully, the plan is which wasn't made available to all the participants, just the speakers, to publish their contributions either as separate papers or as approved conference proceedings in Belgrade Law Review. And you'll be able to read, hopefully in a couple of months. You know, as with journals, a couple is always at least 6. All the contributions from our speakers. Now, at the end, just to open the round once again for some maybe parting words and final comments. Brian?
Okay. So I want to say something about Pierluigi and the remarks, and something about an issue that came up with Torben. So Pierluigi, thanks for the clarifications about what you meant about substantive rationality. I do find the label substantive a little bit misleading. I think this is what threw me. So what it really seems to be is something like the Alexei Habermas view about procedural rationality, that you're supposed to think that under conditions of free and equal discussion, we would arrive at substantive normative conclusions. I will just note that I don't see why we should think that that is true. And I don't think Habermas, you know, who's the source of this idea, has a real explanation of it. but maybe a slightly different label would avoid the misunderstanding. And of course, in the written version, you may be able to make it clearer, but the clarification was useful. Torben, on naturalisms, since you invoke roughly my way of carving up this territory, you talked as though questions about ontological naturalism and methodological or epistemological naturalism were just moving on separate tracks. And of course they could. But, you know, my view is that anyone who's really a naturalist, right, I mean, has to think that the methodological or epistemological naturalism dominates, right? That is, the motivating thought of the naturalism is that successful empirical sciences are our best benchmark for figuring out what the world is like and what we actually know, right? And therefore, ontology, what actually exists, just falls out of whatever the successful empirical sciences tell us exists, right? And this is why, you know, physicalism is more of a philosopher's prejudice than a naturalistic doctrine, because physicalism is not a scientific result, right? It is not a scientific result that psychology is biology, biology to chemistry, chemistry to physics. It's the opposite, right? There are almost no successful reductions. Right? So I think from the standpoint of methodological or as you call it, epistemological naturalism, you do end up with an ontology that is more liberal, right? And you end up precisely because the cognitive sciences don't do any work with physical categories, right? They deal with psychological categories, mental categories, and they do parts of the cognitive sciences do very successful, you know, work with those categories. Therefore, we treat them as part of our ontology of the world. That's related to the whole question about hermeneutics here, right? Given that there are different domains, right? There's the physical domain, the biological domain, the psychological domain, right? What counts as an appropriate method is going to be sensitive to the domain we're talking about, right? So Freud, for example, is a naturalist, but his method, right, is in one familiar sense quite hermeneutical, right? You have to understand how things look, right, to the sick patient in order to figure out what the person's problem is. And as others have said, Hart himself incorporates an hermeneutic dimension because he takes over Max Weber's point, right, that what's peculiar about human beings, unlike atoms or quarks, right, is that human beings are creatures for whom things have a meaning and a significance. And you can't understand or explain social phenomena unless you take account of that. So I agree that there's no fundamental tension between a naturalistic point of view and the use of hermeneutics. And I'll stop with that. Thanks.
Thank you, Brian. Fred?
So one brief substantive comment and one, this is my last opportunity to just thank the organizers, the other participants in the audience. This has been a nice, very nice and illuminating event. So thank you. The one substantive comment, a number of people have talked about the complaint from the so-called pluralists that traditional analytic jurisprudence ignores non-state law. That strikes me as wrong. Indeed, it is no coincidence that Hart uses cricket and what non-Americans call football as his running examples. Much of Hart's work is about non-state law, and indeed a common criticism of Hart is that although he provides an enormously enlightening and enduring description of rule systems and normative systems, he doesn't say very much and not enough about what distinguishes the normative rule system we call law from other normative rule systems. I'll put aside whether that criticism is on point or not, but the very fact that it exists suggests that to think that the Hardian tradition ignores or is not relevant to non-state law strikes me as bizarre. So thank you again.
Thank you so much. Thank you so much, Fred. And we move to Pierluigi.
I have already said my points. I really happy to be here. I wish to thank the organizer because indeed to have an occasion to reflect upon legal philosophy is not a quite frequent event. And we have seen different approaches, which makes the richness of our discipline. I would like to insist on the necessity within an analytic approach to incorporate a strong normative commitment, a strong normative line of inquiry. Analytic jurisprudence is usually associated to descriptive jurisprudence, but analytic jurisprudence is also a set of very powerful tools which do a lot of good, not only in the understanding of legal phenomena, but also in regulating and mastering legal phenomena. So in a sense, my point here is really to advocate for a combined analytic approach, which do both explanatory and normative work. Thanks a lot. Thanks again to the organizers and to the dear friends which I've had the chance to meet and to discuss with today. And I hope to meet them soon personally. Thanks a lot.
Thank you so much, Pierluigi. Tomasz?
Well, it's getting late, so I have no additional comments. I would only like to thank the organizers for organizing this meeting. It was really a great pleasure for me to participate. I benefited very much from the discussions and contributions of other panelists. So really, congratulations. I really think that was an excellent event. So thank you very much for the efforts. But I understand it was not so easy to find the time where all are free. So thank you once again.
Thank you, Tomasz and Torben.
Thank you very much, all. I have little to add. I just want to thank Brian for the comments he made. I'm aware there is a problem there, Brian, and why would you accept ontological naturalism if you are not in methodological naturalism? I guess my thought was simply that you could argue that the reason why I accept ontological naturalism is that I accept methodological naturalism, but still I felt that you could resist bringing those methods into philosophy. That might be a slightly different question, but I mean, that's kind of what I was thinking. So thanks everyone and to the audience for listening to us, and to my good friends here for seeing them and meeting them. It's always a pleasure.
Thank you.
Bye-bye, everyone.
My part, I hope that everybody enjoyed the event as much as I did. Thank you all for answering our call to participate, and I thank all the participants for coming. So, Miodrag, a couple of last words.
Just to thank you all for bringing this event and our ideas. I mean, the idea of having this event to bring it into life. It was really great to see you at least like this. Eventually, we did not have as many technical issues as normally appears with events of this sort. And what is even more striking, we are finishing just in time, 2 minutes before 2.5 hours that we predicted this event to last. So I thank you all, panelists and participants, for joining us, and hopefully that you all enjoy as much as we as organizers did in this event, and hopefully see you soon somewhere in person. Bye.
Thank you all. Bye.
Thank you, Miodrag, Boyan.
Thank you so much.
Thank you.
Bye-bye.
See you soon, hopefully.